Okay, thanks everyone for joining us. Today we're going to give an update on the regulation of embedded networks. We're going to be presenting, following on from some of our recent webinars, looking at the basics of embedded networks and specifically looking at some of the changes since. The presentation will run for approximately 30 minutes and then we'll have a Q&A for 15 minutes thereafter. If you want to send us a question via email, please feel free to do so and we'll provide our email addresses at the end of this presentation. I'll be presenting with Anne Waddell, our regulatory specialist.
Hello everyone.
And the areas that we're going to be looking at today are the Ombudsman membership obligations. So we had somebody in attendance at the E1 consultation forum yesterday. We're going to look at the updates to the Retail Exemption Guideline and Network Exemption Guideline and the Queensland legislation, and then look at some of the misconceptions in the embedded network space, including around retrofits and the need for explicit informed consent. So, Anne, would you mind explaining? We're going to look at the embedded network space.
So I'm sure everybody is familiar with it, but just for the purposes of anyone who isn't, an embedded network is basically a private electricity network connected to the distribution and transmission system through a parent connection point. The users within the network have child meters. They're typically used in apartment blocks, retirement villages, caravan, recreation parks and shopping centres. And they're certainly on the increase, particularly with new apartment developments being built and property developers moving into the provision of utilities within that development. And this has led, as we've discussed many times, to the AER having a better look at regulation and just making sure that customers of exempt embedded networks achieve the same rights and treatment as customers of a retail provider. So there are a number of regulatory challenges within embedded networks for the regulator. And you can see on the screen that we've listed the major ones: limited enforcement options, lack of choice for customers, application of the Australian Consumer Law, dispute resolution, and the use of agents. And the AER has been particularly active recently in the dispute resolution space with the introduction of provisions relating to exempt network operators needing to be part of relevant ombudsman schemes, although that, of course, is under development.
That's right. So the recent amended guidelines, the Network Exemption Guideline and the Retail Seller Exempt Guideline, include a new condition, which is condition 13 in the Network Guideline and condition 17 in the Retail Guideline, which is that where permitted by a state scheme, an exempt supplier is required to become a member of that ombudsman scheme. So yesterday we had a consultation forum that was put on by E1, who are the Energy and Water Ombudsman in New South Wales. There are different schemes in each jurisdiction. The Queensland legislation currently restricts membership of EWOC to authorised retailers. So as we've discussed previously, energy sellers within embedded networks can either be authorised retailers or exempt operators. Authorised retailers would be required to be members of the Ombudsman scheme. The recent amendments make it clear that particular categories of exempt operators, including those listed, are required to be members of the Ombudsman scheme. So the implication of that is that the cost of running an exempt embedded network is going to increase. The Ombudsman scheme in New South Wales has actually four tiers of fees that will apply. The fees that we've indicated are both for a normal authorised retailer. So you can see that the joining fee is $5,450. The annual fee is $8,800. But E1 is proposing to have a scale based on the size of the embedded network, and the indicative pricing that they've given us yesterday is that if you have less than 100 customers, the fee will be $250 to join and $100 as an annual fee. The big one, however, is the annual variable fee, which is based on the caseload of the Energy Ombudsman. So you can see here that we've got different levels of complaints. So you've got an inquiry, a return to higher level. So a return to higher level means that they'll send the complaint back to somebody within the exempt operator or the retailer to try and resolve directly with the customer. And then the more serious levels are level 1, level 2, level 3, up to $3.67 a minute. And that's where the Ombudsman is spending time investigating a complaint. So I've had a lot of experience with the Ombudsman. I used to deal with Ombudsman complaints in retailers and at Integral Energy, the network provider. And I can tell you that it's a reasonably complex process. The objective is to resolve complaints quickly and efficiently, but you have effectively a third party, independent third party, looking to mediate a dispute between the retailer, exempt operator and the customer. And in order to do that, they need to spend time reviewing material, including invoices, customer logs, and so forth. And a complaint that can be quite complicated can easily escalate up until level 1, level 2, level 3, where for an exempt operator, that may have a reasonably significant impact on the profitability of their operation. Well, I might have skipped around a little bit. So yeah, that's basically what's proposed at the moment. The Ombudsman scheme has proposed it's interesting, you've got a different slide than I do. That's interesting. The Ombudsman scheme, that's the present proposal. I think that there'll be further opportunity for representations regarding joining the Ombudsman scheme. And one thing that they indicated yesterday to Alex, our paralegal who attended on our behalf, is that they are open to us entering into a tripartite deed so that we can represent exempt operators. The way that the Ombudsman scheme works is they've got a board, and the board is made up of retailers, electricity retailers, water retailers. But I believe that they're not proposing to have representation from exempt operators, because the issue is obviously that there are going to be a lot more members of E1 than there currently are, and the majority are going to be exempt operators. One opportunity for to make representations of the Ombudsman is that we can form a consultation committee. And if you'd like to talk to us about that, send through an email. And do you mind talking about some of the other regulatory updates?
Yeah, sure. There is a new updated version of the Electricity Service Provider Registration Exemption Guidelines. It commenced on the 1st of March. And one of the areas that was updated with this new version was in relation to protections for energy customers. And as we've been saying, with a view to increasing the involvement of the Ombudsman schemes in the exempt networks, and I guess ensuring that energy customers, regardless of where they source their energy from, have the same rights in relation to dispute resolution and dealing with their retailer or service provider. Do you want to talk about the Queensland one, Colin?
Yeah, sure. Yeah, so exempt operators that operate in Queensland will probably be aware of the amendment bill, and the amendment bill seeks to remove perceived conflicts between the current legislation, which has a definition of an energy customer, and that definition, if read strictly, would exclude an embedded network customer from the definition of customer. So the problem with that is obviously that there's an argument that an exempt customer would not have power of choice. So the obligations relating to embedded network manager could be said to not apply in Queensland. Interestingly, this legislation was delayed because of the change in government in Queensland late last year. Since that time, the Queensland Department has released fact sheets that clearly say that, in their opinion, all customers, including exempt customers, have power of choice. So they've chosen a particular interpretation of the bill, and obviously that probably ties back to the fact that they don't want to be seen as the only state that restricts power of choice within the NECF jurisdictions. The AER has sort of followed suit and updated their material, and so the currently accepted view is that Queensland customers do have power of choice. The transitional period for the appointment of an embedded network manager will end at the end of this month, and the wise thing to do would be to ensure that if you have an embedded network in Queensland that would require an embedded network manager, that you ensure that one is in place by the end of this month. So the status of that bill is that it was deferred to the State Development, Natural Resources and Agricultural Industry Development Committee. They released their report yesterday. It hasn't been published on the website, but we will send you a copy possibly today or on Monday. And the bill is next before Parliament on the 20th of March. So what that means is we may see that the legislation is passed prior to the end of the transitional compliance period in any event.
Well, and then it's more than likely to be passed, isn't it?
Yeah, that's right. Yeah, it's pretty uncontroversial in relation to the power of choice changes. So next we want to look at some of the misconceptions that we've noticed in the embedded network space. We're not going to point anybody out by name, but this is our general observation, and it's also the observation of the Australian Energy Regulator, who we speak to quite often. So Anne, did you want to run through some of those misconceptions?
Yeah, so the first one is in relation to retrofitting or brownfield. And brownfield simply refers to a site that had an existing network system that is being converted to an embedded network. Greenfield, of course, being a new development that is getting an embedded network system installed as part of the building process. So with the retrofit, as everyone is aware, the Condition 4.9 sets out what's required in order to seek approval for the conversion. One of the things is the consent of the tenants, occupiers, to the proposed network conversion. And as this slide points out, that is not the same as consenting to entering into an energy contract with the proposed retailer. They're two separate things, and the AER has requirements around when the poll is taken, recording the poll, and the type of information that must be provided to customers about the proposed network. This is not to be taken as them also then consenting to be supplied electricity in that network by the proposed provider.
Yeah, and one thing that we've noticed is a lot of providers assume that that requirement in section 4.9.1 means that they can just talk about the benefits of a retrofit. That's not the intention. You know, the intention of 4.9.1 is that you adequately disclose those points that are listed in section 4.9.1. The AER expects you to talk about the disadvantages of a retrofit, even if you're guaranteed that you're going to be providing some sort of saving to consumers. The AER wants you to talk about potential disadvantages. And one of those might be, even in the case of an authorized retailer, just the fact that even with an embedded network manager, it is going to be harder for a customer within an embedded network to switch out to another retailer. And that's because of the separate provider of the network component of the bill to that exempt end user. So the AER doesn't want you to use that as a marketing campaign just to talk about all the benefits of the proposed embedded network. They want you to have full disclosure, and the AER won't approve your embedded network conversion unless you've shown that you've done that.
And it just comes back to, and we recently had a webinar on explicit informed consent. The consent that is required to be given is explicit informed consent. And in order for it to be informed, the customer needs to know the pros and cons. It can't just be, what do they call it, a soap job?
Yeah, or
What's
sort of
it
tick
called?
box compliance.
Yeah, and it's all going to be great. The smart operators, like smart lawyers, you're always aware of the negative, you address it head on and you deal with it. And so that's part of the discussion you have, is you don't shy away from certain disadvantages, but you deal with it and you explain it in clear terms to your customers so that the AER is comfortable with the degree of knowledge and consent.
And that applies not just as a point in time, it's not a point in time concern. You have to realise that the AER can come back a year later, 2 years later, and say to you, give me records that demonstrated that you've complied with these requirements. You only have to watch the Royal Commission on the banking industry to see that things get dug up after the fact. So the only way to do it properly is to make sure that you're providing the right documents at the time that you're seeking consent, and that you're comfortable with your processes.
The best evidence of anything is a contemporaneous document. A document created at the time of the event will always be the best evidence that that thing occurred.
That's right, yeah. So another misconception we're seeing in the industry is this concept of trying to sign up a developer for a future development and assuming that the occupants who move into that development will just be supplied by you. This ties back to this obligation to obtain explicit informed consent. There's no way for a developer of a building that hasn't been built to supply consent on behalf of a theoretical tenant who hasn't even moved in. And I think that we're going to see the AER looking at this area. A lot of people assume that the value in an embedded network business is the number of buildings that they own. The push in the regulation is towards power of choice. So that assumption that you have a set number of customers needs to be re-examined, because those customers should have the same right to move out. The only reason that they would want to stay in is if you're offering an offer that is better than what they would be able to receive from grid-sourced electricity or another authorised retailer.
And this notion of the benefits that attach to an embedded network that aren't always able to be quantified was raised last year at one of the forums I attended in relation to changes to the embedded network structure. And the regulator's view was you need to be able to quantify that benefit in some way and list it or talk about it with the customer. So, for a lot of developments, their view will be that the customer is getting these implicit benefits from all being on the one network. It's not enough just to say that. You have to be able to quantify or identify what you say are these additional benefits that the tenant is getting from being part of the network.
That's right. We've already looked at the Queensland legislation, so we'll move on.
Connor, I just think on that one, you've got it on the slide. It's important to understand that a body corporate, strata community, whatever it may be called, it's the same with them. The body corporate can't, on behalf of all the users, the residents, sign up. The body corporate can enter into an agreement in relation to the common areas, but the actual residents, tenants need to enter into their own supply contracts.
Yeah, and one contract that we commonly note is missing is the network supply contract within the embedded network. So you would require not only a retail supply contract with your customers, but there needs to be a what's called in the on-market space, a UOS agreement, which is a use of system agreement. And that's particularly important if a customer switches out and you're supplying the network component of the bill only. You need to have a contractual mechanism to actually enforce those charges. So that's something that we've noticed. People focus on the retail side. They do a deal with the body corporate and then they'll sign them up to X number of years on the basis of the infrastructure that's being supplied. They forget about the fact that they're providing a network service to the end user as well.
Yeah.
So the next area of misconception, we think a lot of people, go onto the AER website and apply for an exemption, and they might just sort of glance through the conditions that apply to that exemption, but we think that they should probably re-examine their activities to make sure that they're compliant. One of the obligations is that you provide information, so that's condition 2, and that includes information about the ability to access the Ombudsman scheme or a dispute resolution scheme. Condition 4.8 of the network guidelines matches the retail exemption obligation, and that information must be provided at the commencement of the contract. Must also be provided on a request. So what you need if you're an exempt operator is a standard form information disclosure sheet that we can review for you that complies with the information provision requirements of the retail and network exemption guidelines.
And the notification must be in writing. And here on this slide, this is the provision which lists out exactly what it is you have to include. And as Connor said, you can provide an information sheet that has that information in it, but it must be provided to the customer at the commencement.
Yeah, and a lot of embedded network operators who are authorised retailers forget about the fact that they're often providing the network service as well, or that they're partnering up with the body corporate to provide that service. So whoever is the exempt network operator, even where an authorised retailer is supplying electricity to an embedded network, that party needs to make sure that they comply with this section 4.8.1. And that's something that is also overlooked. In a lot of cases, multiple parties require an exemption on the network side if they own, control or operate that network.
And just one thing before we flick off the slide, Connor, is notice that you have to provide a copy or a link to the conditions applicable to your particular exemption. And although there are general conditions, you need to ensure that you know which of those general conditions applies to your particular exemption. And if there are special conditions that have been imposed by the regulator as part of the granting of your exemption, then that must also be made available to the customer so that they know. So it's not enough to simply link in to the guidelines and the conditions. You've got to make sure that if there's any additional conditions, they're also accessible to the customer.
We often get the question about the emergency contact number. So the question is usually, well, should that be Ausgrid or the LNSP, or should that be the exempt operator? Our opinion is that you probably need to list both, but you definitely need to list your own 24-hour emergency contact number. Simply giving them Ausgrid's number wouldn't be sufficient, because there might be a fault or an emergency that is localized within the exempt embedded network, and the responsibility for that lies with the exempt embedded network operator.
And it's one of the obligations that you have as the holder of an exemption or a retail license to deal with any disruption of service, particularly relevant if you have life support customers.
So, yeah, we've already spoken about this, that the information must be provided at the commencement of the contract and provided on request.
As you can see from this slide, this one is actually from the November draft, although that is operating now. We thought it was worthwhile to show you the amendments because it simply highlights the importance that the regulator is putting on the ombudsman schemes within exempt networks. They have shifted the order of dispute resolution notification. So subtly changing the emphasis in terms of who the customer thinks they should go to first. With these guidelines, they're saying ombudsman and then your dispute resolution. So it's just a subtle shift in emphasis in relation to the AER viewing the ombudsman schemes as the preferred dispute resolution venue.
And so finally, we'll just quickly look at the Embedded Network Manager. So one of the activities that we've been undertaking, we've been applying for a reasonable number of retail authorizations, but also Embedded Network Manager accreditations. And the important point to note is that the transitional compliance period ends at the end of this month. And really, people who operate an embedded network will need a written agreement with an embedded network manager if they're not going to complete that role themselves. The embedded network manager role, if you've attained that accreditation, you'll know that you would have been through an initial audit, and then from what we've heard from AEMO, the follow-up audit is most likely going to be in around about November. We've been working on developing some systems to help embedded network managers comply with their obligations. So if you require some assistance in that area, please get in touch.
Well, you recently assisted in an audit, didn't you?
Yeah, that's right. So we set up a version of our compliance hub. So the compliance hub is our compliance system. Our system was audited, and we got a very favourable result, and it's purely on that basis that they want to see, as we said before, contemporaneous documents. They want to make sure that you've made the right disclosures, that you've followed the right process. Less so for the embedded network manager in terms of disclosures, but certainly that you followed the right process and that you're keeping records of the things that you're doing. The overall trend that we see is that this concept of embedded networks kind of being this separate space is quickly disappearing. Yeah.
And it's interesting too, because there was a recent penalty imposed on a property developer in South Australia, $60,000, because they had, I think it was 3 or 4 shopping centres. They were supplying electricity to the customers in those shopping centres. and they had neither an exemption nor a retail license, and they got pinged. So I think, the days of shopping centre owners or property developers thinking that they can just supply energy, and she'll be right, mate, if they ever existed, certainly don't exist now.
That's right. We also saw an article, which is one of the first sort of press, interest in the area on SBS. And, in my opinion, the article was completely factually incorrect. It was talking about embedded network customers being locked in and getting a worse deal. And, we know that that is the case in some circumstances, but by and large, with the majority of people that we deal with, embedded networks are there because they achieve a benefit for those customers. And I think the challenge is in communicating that benefit whilst also fitting within the regulatory regime. And obviously the regulatory regime is tightening up because of that, easy perception that, well, they're kind of locked in, anything can happen to them. They don't have the same consumer protections. So these changes are going to remove that disparity.
And I also think it's important, having worked for 3 decades, which is a very long time. I should be retired.
You started when you were 5.
Yeah. Anyway, I have worked with many marketing departments, and I would say to people that are contemplating getting a conversion of a brownfield site and going through that explicit consent process, because part of it is doing a marketing campaign and the regulator wants to see your marketing. It's important that the people that are doing the marketing campaign are actually aware of all the requirements of 4.9, that they understand what the concept of explicit informed consent is. Don't let the marketing people run off with the fairies, as they so often do. Nothing against marketing people, but they are in fairyland, because the regulator may look at your campaign and say, all very nice, but you didn't tick the right boxes, and you'll have to go and redo your campaign, polling, whatever. So, as with a lot of things with energy, it's interdisciplinary, and the right hand should know what left hand's doing, if at all possible.
Yeah, that's right. And another point just on the Ombudsman scheme. So the Ombudsman has a tripartite, or a deed with the regulators as well, so with AEMO and AER. And I think that what you'll see is if the Ombudsman identifies compliance breaches within the complaints that they're now going to be receiving, then you can expect that we're going to see more AER enforcement action into the future.
And also don't forget that the ACCC has energy in its sights for this year. It's got a gas review, electricity review. They, of course, are looking at pricing and what information is being told to customers to induce them to enter into contracts. So there's a lot of eyes on the energy retail space in 2018.
That's right. Yeah. So that's the end of our webinar for today. Thanks for joining us. We run a series of webinars. So we run webinars that are open generally, such as this one, but also for those that are our customers. We run at least 2 webinars a month. Future topics we're going to be looking at include microgrids, some more about energy storage, and so on and so on. If you've got any questions.
Yeah, and we certainly will be continuing to provide updates on embedded networks, because that is going to be a very active space this year and probably next year as well.
That's right. All right. Thanks for joining us, everyone. There's no questions that have popped up. So just if you've got any questions, email them through and we will distribute the answers to everybody that's attended. Otherwise, have a good Friday and a good weekend.
And don't forget beer o'clock.